Alright, today is the 11th of September 2023 and the time is 21:20. Okay, I'm doing this video for myself, for my studies, so it's not intended to educate students. Study unit 1.1, the classical school. The offender is calculator. Learning outcomes. After working through the study unit, you should be able to describe the following assumptions listed below of the classical school of criminology: human nature, conceptions of society and social order, causes of crime, implications of policy. Explain the limitations of the classical school of criminology. Describe the attributes of the classical and neoclassical schools of criminology as foundations of the rational actor model. Time required for study unit. The study unit will require approximately 5 hours. Visual overview of study unit, and then we have a figure here. With visual overview of the study unit 1.1, and then we come to introduction. The classical school of criminology grew out of the age of enlightenment in the 17th and the 18th centuries. Among the thinkers of the time was Sarase Persana Meches de Bakari, commonly referred to as Cesare Beccaria, who is often credited as the father of the classical school of criminology. The notion of the classical school was that it is better to prevent crimes than to punish them. The classical school of thought is therefore based on the tenet that human problems should be addressed by the application of reasons rather than tradition, religion, or superstition. At the time, traditional explanation of crime were being replaced by explanation that focused on rationality, individual responsibility, and free choice. Some of these Enlightenment thinkers turned their attention to the nature of criminal law and punishment and put forward radical ideas for its reform. In short, they opposed the unpredictable, discriminatory, inhuman, and ineffective criminal justice system of their day. The program for changing the state of affairs was to produce a system in which law and punishment were predictable, non-discriminatory, human, and effective. Therefore, punishment follow as certainly as quickly as possible after the offense and be just sufficient to act as a deterrent to the crime. The three principles of punishment are, therefore, certainty. People must be certain that there will be punishment for any and all illegal behavior. Swiftness. The punishment must be meted out as quickly as possible so that the association between the punishment and the crime will be preserved. Severity. The punishment must be proportionate to the illegal act. This is to say that the punishment must be severe enough to outweigh the reward of the illegal action. Another key classic school theorist was Jeremy Bentham from Britain, known to admire Beccaриa's work. As a reformer of classical school of thought, he posited that people make decisions based on the pleasure-pain principle, hedonistic calculus. The assertion of this principle is that people would rather deterrent and not an act of retribution for a crime. These two thinkers established the essential components of the rational act model. However, this model was based on a number of assumptions. Think of another part of the world. Does the rational actor model apply effectively in South Africa? Compare your thoughts with the following article on Sri Lanka and the application of the classical school of thought. You can find it on the following link in lessons 1.1 of the initial model site. Assumptions of the classical school of the rational actor model will be listed and explored in the following sections. Assumptions of the classical school of criminology. The assumptions of the classical school of the rational actor model are summarized in figure 1.1.2 below. The assumptions of the classical school of rational actor model are each explored below, starting from human nature rationality. Human nature rationality. According to the classical school, people are self-interested, rational creatures, able to weigh up the advantages and disadvantages of competing causes of action, who are able to make and act in accordance with the personal choices. Often described as free will, the emphasis on the individual offender as being a person who is capable of calculating what he or she wants to do is the most important feature of the classical school of thought. Those who fail to make rational choices, therefore, and who commit crime are sent to prison with a view of reform. The idea is to encourage them not to commit crimes in future by developing their rational thought processes. Conformity was associated with the rewards and rebellion was associated with sanctions. Conception of society or social order. Left to their own devices, people will follow their own selfish interest, and since these will often conflict, this will result in chaos. Therefore, criminal laws are instituted to form an exchange between the state and individual. Because people are rational, individuals must rather opt to receive protection of their rights to welfare and private property in exchange for their freedom not to comply with the state laws or act at their own discretion. The state uses laws to protect individuals, and this is in effect social contract, and it conforms the basis of social order. A violation of law is a violation of this contract and justify the state's right to punish the offender. Causes of crime. Since people are normally rational creatures, it seems to follow that either the pleasure or gain from the crime outweighs the pain of punishment associated with it, or that some people make irrational decisions for some reason. One example, these reasons could include the institutions of law or education possibly sending out wrong or confused messages so that people do not have the appropriate information to make rational decisions. Furthermore, crimes are caused by lack of appropriate punishment. Again, according to this school of thoughts, behavior is guided by the hedonistic calculus, pleasure-pain principle, by which potential offenders calculate the risk and rewards involved in their actions. Therefore, the decision to commit crime was viewed as the consequence of a logical thought process. Implications for policy. Criminal justice should be subject to a strict rule of law. Due process and punishments should be known, fixed, and just severe enough to deter. Judges' discretion should be minimized as far as possible in sentencing. Classicists argued that the most appropriate solution to crime was clearly defined and consistently applied legal code and a criminal justice system that was predictable and also swift in its operations. This would ensure that potential offenders were aware of this inevitable personal cost of committing crime. Classicists refer to a criminal justice system that is predictable in its own operations. Why then do not all murderers get life sentences? List your reasons. Feedback, you refer to something. Take note. All sentencing and bereaved family and friends are not always satisfied with the offender's punishment. The social and physical characteristics of the offenders play a decisive role in his or her sentencing. However, according to the classical school, punishment should be suited to the offense and not influenced by social and physical characteristics of the offender. Therefore, intent was deemed irrelevant. The harm which a particular criminal action did to society was quickly yardstick by which the classicists judged the appropriateness of punishment. Next, we examine the limitations of the classical school of criminology, starting with the neoclassic school of thought. Limitations of the classical school of thought, school of criminology, neoclassical school of thought. The application of the classical school of criminology during the 18th century quickly revealed flaws in the idea of identical punishment for identical crimes. Furthermore, its foundational concepts of free will and rationality also shows flaws. Social theorists discovered that aggravating and mitigating circumstances sometimes meant that similar crime differed in significant ways. Also, while the concept of free will was not abandoned, people recognized that there were sometimes circumstances in which freedom of choice was limited. Likewise, under certain conditions, people did not always act rationally. Rationality might be constrained by factors such as poverty, insanity, immaturity. In fact, the classical theorists had completely ignored differences between the individuals. First offenders and repeat offenders were treated exactly alike, solely on the basis of particular act that had been committed. Children, those who were mentally illness and intellectual challenges, were all treated as if they were completely rational and competent. All this quickly led to classical criminologists to revise their idea. The change of classical criminology resulting from these realizations developed into what became known as Neoclassical criminology. According to neoclassical thinkers, a person is still accountable for his or her actions, but with certain minor reservations. It is acknowledged that the offender's past history and present situation both influence the likelihood of reform. Ordinary rational adults were still considered fully responsible for their actions and all equally capable of their criminal or law-abiding behavior. It was also recognized, however, that children were less capable of exercising free choice and were therefore less responsible for their actions. Those with mental illness and intellectual challenges might be even less responsible. It was this revision to the penal code that admitted into our courts for the first time non-legal aspects, including doctors, psychiatrists, and later social workers. They were gradually introduced into the criminal justice system in order to identify the impact of individual biological, psychological, and social differences. The purpose of this intervention was to determine the extent in which the offenders were responsible for their actions. The outcome was that sentences became more individualized depending on the perceived degree of responsibility on the part of the offender and on whether they were mitigating circumstances. Buick identifies the following central attributes of the classic and neoclassic schools, which laid down the foundations of the rational actor model. The fundamental concentration of the criminal law and the legal definition of crime. The central concept that the punishment should fit the crime rather than the offender. The doctrine of free will, according to which all people are free to choose their actions. From this perspective, it is assumed that there were nothing different or special about offenders that differentiates them from other people. The use of non-scientific methodology coupled with lack of empirical research. In other words, the classical and neoclassical schools created an administrative and legal criminology that was more concerned with the uniformity of the laws and punishment. Neither school really tried to explain criminal behavior. Activity 1.2. Visit a news aggregator site. Online, identify 3 legal experts: ballistic, psychologist, forensic pathologist in the Oscar Pistorius murder trial 2004 in South Africa. Then further identify how these experts explained the extent on which Oscar was responsible for his actions. Time for activity is 35 minutes. Feedback, summary, and conclusion. Classical theorists view criminal behavior and deliberate activity result from rational decision in which offenders weigh the advantages and disadvantages and perform the illegal act that promised the greatest potential gain. Those who commit serious crimes or continue to break deserve deserve punishment because they possess free will and know what they are doing. People are influenced by their fear of punishment, association with being caught and convicted for law violation. The more severe, certain, and swift punishment, the more likely it is to control crime. The classical school of criminology is therefore founded in rationality, hedonism, punishment, and human rights. The neoclassical school represents no major break with the basic premises of the classical school. The neoclassical school of thought continued to state that the people have free will and that people are rational creatures guided by reasons. They also claim that people are controlled must exceed the pleasure obtained from the act. However, the neoclassical school made some modification to the administration of law based on the classical school. Neoclassical thinkers modified the doctrine of free will by stating that the freedom of choice could be influenced by the incompetent. They also introduced the concept of premeditation and mitigating circumstances. The classical thinkers initiated a period of lasting debate and controversy over how we should understand crime and criminal behavior. Although the focus on The focus is on the offense rather than offender. The very process is raising issues concerning law and offending leads to closer scrutiny of the reasons for offending. It is the reason for offending that form the basis of the theories in theme 2. Self-assessment. Time for activity 60 minutes. To test and evaluate your knowledge in the study unit, complete the following. Make sure you have mastered the key concepts that are listed at the start of the study unit by making brief notes so that the meaning of each term is clear. Make summary of study unit. Answer the following multiple choice questions followed by paragraph type and longer typed questions. Who are the two new contributors to classical school of thought? Number 4. Ansala. The thinkers of philosophers and the age of enlightenment turned their attention to the nature and punishment of people. In short, they the effort of the in their days. They opposed the efforts of the criminal justice system of their day. Okay, I think Utula. Identify the central attributes of the classic and neoclassical school of thought. The fundamental concentration of criminal law and legal definition of crime. Punishment must be severe enough to outweigh the rewards of the legal action. The central concept that the punishment should be fit for the crime. People must be certain that they were punished for any, I think, with 2 and 3. Kone answer njalo. One number 4 for la. A judge in court of law presided over 2 similar cases of murder. The first case was a woman who killed her husband in self-defense, and the second case was that the woman who killed her husband so that she can claim on his life insurance. The judge imposed both women with the same sentence of life imprisonment, despite their mitigating factors. Which school of thought influenced the judgment? One. An elderly man who often drinks in a pub in town always intentionally leaves his car at the pub after getting drunk. He has a right to drive his own car even if he's drunk, but he would much rather take an Uber back home so that he does not get into trouble with the law. By doing this, what has the elder man taken note of? His rationality, his personal safety, the social contract, the severe of punishment. 4. Okay, I think I'm done.